leave. So if, for example, you as an employer ask an employee to self-isolate, it's difficult to see how you could justify making that unpaid. If, on the other hand, let's say an employee chooses to travel to China and on their return is quarantined, whilst the law doesn't specifically allow for it, you can imagine that in the event of a dispute, the courts may have more sympathy with an employer saying, clearly, we're not going to pay you for this. I think it comes back to the practical element as well. So, again, you as the employers want your employees to let you know if they have traveled to a high-risk destination, if they have come into contact with someone who may have COVID-19. And if you publicise to your employees that any period of self-isolation will be unpaid, you may be discouraging them from coming forward. So there is that practical element to think as well.
So I guess there is a lot of overlap in the different areas that we've covered today, but we will get back later on into the reporting question and to know, do we have to report, who has to report, and how can people accountable? If my employer asks me to stay at home, do they have to pay me?
Yeah, so I touched upon that, I suppose, in the last answer. So if your employer asks you to stay at home, if they ask you to self-isolate, it's difficult to see how they could justify not paying you in those circumstances. As I said, the labour law doesn't actually allow for unpaid leave anyway. From an employer's perspective, what they should instead be looking at really is whether they can mandate annual leave. So that's permitted under the law. You can require someone to take annual leave. That would obviously need to be paid. And also a topic that we'll obviously talk about in more detail later, but looking at whether employees can work from home when they're being isolated.
So just to confirm, so the employers can require their employees to take annual leave. Is there a maximum limit to that? And what happens if employees have already exhausted their annual leave?
Yeah, so I suppose in ordinary circumstances, you would only require employees to take the leave that they have for that particular leave year. One thing some employers are looking at is whether they allow employees to borrow from a subsequent year's leave to enable them to take time off, which is paid in the usual way.
That's really interesting. That'd be really interesting to see whether companies are looking into doing that right now, and what kind of arrangements they're coming up with. What about unpaid leave? So suppose that employers do not offer employees to borrow days from the next years. Can they force them to take unpaid leave? And is there any protection for employees?
Yeah, so as I said, there is no right under the labour law to mandate unpaid leave, and where an employer does, there is a risk of claims. What I suppose is better from a practical perspective is to try and agree periods of unpaid leave. Now, on the face of it, that may seem difficult. You're asking an employee to agree to something that ultimately isn't to their benefit. But I suppose if you clearly communicate what the alternatives are, why you're doing it, it's a protective measure, it's a measure to address some of the financial implications, then you may find that employees are willing to agree.
So obviously we have said as the CIPD and put forward resources for you as employers, we do encourage you to try and find solutions for your staff and teams to work from home wherever possible, rather than to have to resort to unpaid leave. And like Samantha's mentioned, so there are creative ways in which employers can find solutions, whether it is looking at extraordinary ways to borrow leave from the next year, or whether it's things like launching a fund to cover for employees that cannot work, in the example of labor or restaurants or delivery drivers, or companies. We have seen companies like tech giants keep paying hourly staff even if they are asked to stay from home due to COVID-19. So there is again a question of reputation and of the duty of care that you have to your employees. So we talk a lot about remote working, and I think it's been the talk of the town today. Does the law in the UAE permit remote working?
No, it doesn't. It doesn't. It doesn't address it. It doesn't permit it, but it doesn't prohibit it. I think historically there hasn't been a huge prevalence of home working in the UAE. We're perhaps a little bit behind some other jurisdictions in that sense. There has generally been a presumption that employees will perform their work from their employer's premises. As I said, the law doesn't specifically prohibit it. The law was drafted in 1980 when the UAE was a very different place, of course. And of course, the government itself has announced that its employees will be working from home. So I think it's extremely unlikely that employers would suffer any negative consequences as a result of implementing working from home processes.
So it's obviously blurry because you're saying there are no regulations. So does an employer still have obligations in regards to home working? For example, do they need to assess an employee's home working area? Are they responsible for ensuring that they have sufficient facilities, laptop, connection? What if an employee cannot work from home? So what can we say about that?
Yeah, so again, I suppose there's the legal answer and the practical answer. From a legal perspective, given the law doesn't specifically address the issue of home working, it follows that it doesn't specifically mandate what you need to do and not do it when your employees are working from home. So there is no express obligation to assess an employee's home working space, for example. However, there are obviously obligations relating to the workspace itself, and where an employee's workspace becomes their home, then arguably some of your obligations as an employer could extend there. I think from a practical perspective, employers aren't necessarily going to, nor should they be expected to start going to employees' homes and checking their workspaces. But I think what is sensible is to have policies and procedures in place, particularly for organisations where this is a new concept. For organisations where employees haven't historically worked from home, won't be used to working from home, and some of the challenges that can create, having some policies and guidelines in terms of what they should and shouldn't do, confidentiality, etc., is really sensible.
Okay. What other practical things should employers consider in regards to there anything? So, because I guess when you say there are obligations around workplace, you're mentioning policies and procedures. Is there anything around health and safety? If I contract a virus while working at home, is this contracting it while at my workplace?
Yeah, I mean, again, all sensible questions that I suppose aren't addressed by the law. A workplace injury is defined really broadly under the labour law and could potentially include injuries that are sustained whilst you're working from home. I think that's where policies and procedures can be helpful again in terms of setting some guidelines and expectations around safety whilst working from home. The other practical things to think about, I touched on obviously confidentiality. So, employee, depending on the nature of your business, does this mean that employees are going to be taking company confidential information home? How do they protect that? Are they going to be working from other locations, and how do you maintain the confidentiality of your information? Technology, for lots of organisations, this is new. Even for organisations that are used to a certain percentage of the workforce working from home, won't be used to this scale. And so, do you have the technology that supports it?
It's a question that's even being raised at a national level in many countries where we're not sure whether the servers can actually cope with the Wi-Fi demand. Yes, we'll find out. So we're getting quite a lot of questions. We are reading them. So Pauline, Hamad, Ansen, we're getting to your questions in a few moments. So I guess we are getting into the financial implications of this. Some industries are being hit economically quite hard and are experiencing a huge drop in profits or in demand, especially aviation, hospitality, service industry. sorry, can they legally terminate employees so long as they honor contractual obligations? So notice period extra.
Yeah, so it will depend, obviously, whether we're looking at the UAE labour law or the DIFC employment law. In the DIFC employment law, in some ways it's more straightforward. There is no right for an employee to claim unfair dismissal, but they can raise other claims relating to their termination, such as discrimination. So in theory, yes, you can terminate someone by reason of redundancy, but you need to make sure you are not falling foul of the discrimination legislation, and that if there were to be a claim, you can evidence why you've chosen particular employees, that it's not due to a protected ground, etc. Under the UAE labour law, it will depend on the contractual terms, but for those engaged on an unlimited term contract, the termination needs to be for a valid reason. Now, the labour law says that a valid reason is related to an employee's work, and that's generally interpreted as meaning either poor performance or misconduct. And so for that reason, terminations for redundancy, for financial reasons, are typically found to be arbitrary when they get to the labour court. So to answer your question, yes, you can terminate, but you do run the risk of a successful arbitrary dismissal claim. And employees would then be entitled to compensation in addition to their notice, their gratuity.
So I guess here it's helpful to maybe define redundancy. A lot of companies, let's say restaurants, etc., might suffer from a drop in demand for a couple of weeks, couple of months. It's hard to find out. No work, no pay. Is that legal? And would that be considered redundancy if there is not enough demand?
So, I mean, the law in the UAE doesn't deal with redundancy, so there is no legal definition of redundancy under UAE law where if it meets this definition, you're fine. You know, you come back to the point that it has to be a valid reason for dismissal, that has to be related to the employee's work, and where it's due to a downturn in business, COVID-19, you know, reduced need for staff, that is a business-related reason rather than a reason related to the employee's work, and therefore you run the risk of an arbitrary dismissal claim. It's obviously something that lots of employers are going to be considering and potentially having to implement in the coming months. From a practical perspective, the way that some employers will manage it, knowing that there is a risk of an arbitrary dismissal claim, is either invite volunteers. And if you volunteer for redundancy, you get an enhanced termination package, which is recorded in a settlement agreement. Or instead of inviting volunteers, because perhaps you know which employees are no longer needed because of the way that your business has changed, you just have settlement discussions with them from the outset. So again, you would ask them to sign a settlement agreement. You would pay them something over and above their statutory and contractual entitlements.
So can employer, I guess in between, in all those grey areas, some employers are looking at salary reductions so as not to get rid of people, or unpaid leave to reduce headcount costs. I've specifically had a question this morning from one of you guys where they said that their employer had asked them to work 4 days a week with fewer hours. So there is one salary reduction, and two, there is a compulsory 1 day a week that had to be taken up for the next couple of months.
Okay.
Is that legal? What can we and cannot do in those?
So all of those things, whenever you're looking to change an employee's contractual terms, it needs to happen with an employee's consent. If you don't have their express written consent, you are at risk of breach of contract claims. Now, again, as I mentioned in the context of trying to agree unpaid leave, obviously on the face of it, trying to get an employee to agree to a reduction in salary or reduction in working hours may appear difficult. But if we come back to, you know, why are we doing this? What are the alternatives? Is this an effort to try and avoid headcount reductions? You may then find that employees are more willing to agree. The key, whilst there's no statutory obligation to consult, I think the key is consultation, communication, explaining to employees why you're doing this. There are things that you can think about to try and alleviate the impact. So if an employee has a reduction in salary, for example, so they're moved to part-time, they have a reduction in salary, that would have an impact on their end of service gratuity, which is calculated based on their final salary. So you could, for example, consider ring-fencing gratuity accrued up to the date of the change and then calculating it based on the reduced salary going forward. And again, it comes back to the importance of communication and consultation. You know, as part of that process, you will hear about the pain points for employees, and you should, if you want to get their agreement, try to be receptive to that and be flexible in terms of how you're implementing those changes.
Right. So if we've recently made an offer of employment, which due to the economic impact of COVID has to be withdrawn, are there any risks associated with this?
It will very much depend on the terms of the offer. So our recommendation would always be that your offers of employment are made conditional on certain things, such as receiving references, but also on receiving immigration approvals, which obviously, given the restrictions that have been implemented recently, may not be possible at the moment. So you need to look at the terms of the offer. Was it made conditional, and have those conditions been met? If the offer wasn't conditional, then yes, there are risks, and the extent of those risks will very much depend on the terms of the offer. So it will need to be considered on a case-by-case basis.
Great. So we'll try and take a few questions that are very much around this. If a new visa issuance is either put on hold or is taking time, so it goes back to the fact that visas are being frozen, what are the obligations of the new employer towards the employee on overstay and fines? Do we know that? So you've already had someone who's working with you, their visa is under process and it's taking more time than it should, or it's being put on hold and they've started working with you. Yeah. Should you cover any of these overstay fees or bear any of the responsibilities in that case?
So this might be a helpful time to clarify what the immigration restrictions are, because I think there has been a bit of confusion around that. So the restrictions apply from today, and it's a suspension of applications for employment entry permits for non-nationals that are based outside of the UAE. Also for mission visas for individuals based outside of the UAE, and for pre-applied for visas. So, for example, tourist visas for those who aren't able to get visas on arrival. The restriction doesn't apply for visas that are applied for in country, which would address the question that's been raised. It doesn't apply if you're already in country. There is no restriction on getting another visa in country. It doesn't apply to renewals, and it doesn't apply to visas on arrival or visa-free entry. So if you are of a nationality where you can get a visa on arrival in the UAE without any pre-application process, that at the moment is still able to proceed.
I guess around the world, European countries and the United States have had to kind of backpedal after they've announced some immigration restrictions that weren't necessarily clear in the beginning. So to summarize again, you still can get entry on arrival. If you're already here and already working, your renewal is not affected. So if you're already resident, you shouldn't have any issues. It's really if you need to, if you have a pre-approved visa, missions visa, or employment entry permits.
Yeah, so the big impact really will be on recruitment of individuals who are currently based outside of the UAE, and the restriction is on new and pending applications. So if you've made an offer of employment, you are in process of getting a visa for someone who's currently outside of the UAE, that will now be put on hold, and you need to think about whether you are either going to extend the start date or whether you need to withdraw that offer. and all of the points that we've just discussed are therefore relevant.
So before we move forward into immigration, I see we're still getting a lot of questions around financials, and maybe some people tuned in a little later. So if someone is on a visitor tourist visa, can it be extended or get a new one? I guess that's not so much employment law, but do you want to take that question? If someone is already here on a tourist visa, on a visit visa, can it be extended or can they get a new one?
Yeah, so there has been no change to the general position around visas on arrival. That has been clarified. I think there was some ambiguity in terms of the original announcement, but that has been clarified more recently, that if you're eligible for visa on arrival or visa-free entry, there is no restriction.
But if you're not, so let's say you are a national from a country where you need to get a visa beforehand, you're already here, and now what you would normally do probably would be a visa run or renew your visa and pay and apply for it. In that case, then do you have to go out and wait until this whole thing is over?
I think it would come back to, so there's no impact on renewals. Okay. So if you could ordinarily renew, fine. If you have to go out and come back in, that's where the restriction is now in place.
So I think we'll move forward from the immigration. Before that, I just want to go back to the payment questions. So a lot of questions around termination. In case of termination, can a terminated employee demand a certain package which has been applied to previously terminated employees, such as a 3-month paid notice period? So I guess we're saying that you could be sued for unfair dismissal if you do not honor your contractual obligations. Is that what you said earlier?
Yeah, I mean, I think the question is around custom and practice and whether employers are bound by enhanced terms, presumably, that they have provided to previous employees. I guess it's kind of getting slightly outside of COVID-19 and its implications and moving more into kind of general termination questions. The UAE labour court system is very much paper-based, so it's all about what you can evidence in writing. So if an employee could evidence that previous employees got a certain package on termination of employment, then in theory they may have grounds to say that they're entitled to it. But it very much depends on the circumstances, and I suggest that if that's a particular issue for you, we talk about it offline.
Sure. So then the majority of the questions again are around if the government decides to close malls, close hotels, close all those industries, and we don't have enough demand, can we terminate people? And so that goes back to our earlier discussion. You can legally terminate employees so long as they honor, if you honor your contractual obligations, but you must have a valid reason. We said earlier with Samantha that it is preferable that employers look at finding an agreement with employees, right?
Yes, because redundancy isn't typically going to be a valid reason for dismissal. There have been some cases in the Court of Cassation where the courts have upheld terminations by reason of redundancy as valid, but that tends to be where the company is closing down entirely or is shutting a particular department. So if that's what's happening as the result of COVID-19, then perhaps it would be less risky. But if you're just looking to lay off part of your workforce because you've been hit financially, there is a risk of an arbitrary dismissal claim if you fall under the label.
Right, because then you could say, oh, we're having a bad touristic season and we just lay off people because we don't have people visiting us. And that would not be okay or rightful by the law. So again, if an employee is terminated and the termination is arbitral, do the employer need to pay the employee notice period and an arbitrary dismissal, which is 3 months' salary, I guess?
So the compensation for arbitrary dismissal is up to 3 months' pay. The court has discretion to award less depending on the circumstances. And yes, that would be in addition to an employee's statutory and contractual entitlements. So in addition to their notice, end of service gratuity, their accrued untaken annual leave, and any other contractual entitlements.
So we've spoken briefly about the gratuity, and you've mentioned, of course, the gratuity is calculated based on the last salary. So is there a way to work around this? So if I were to, if an employer is to ask an employee to accept a salary reduction, can this be time bound so that it, or does this have to be written in paper? Can we lock in the gratuity which is owed to the employee, and when things go back to normal, do we go back to calculating normally?
Yeah, I mean, those are all practical things that employees are likely to ask before agreeing to a reduction in salary, and something that you as employers need to consider how you will deal with. In the financial crisis, similar situation occurred. Employers were making salary reductions. Where you fall under the ministry's jurisdiction and you're reducing the salary to below the level in the ministry contract, that can potentially cause issues under the wages protection system, but also will require the issuance of a new ministry contract. And what the ministry were requesting back then is that employers do exactly that. They ring-fence gratuity that has been accrued to date. Even if you don't fall under the jurisdiction of the ministry and it's not something that's requested, I think it's a very sensible way of trying to get an employee's agreement to the change. And then you said about whether it would revert back if there are salary changes in the future. I mean, yes, as a matter of law, it would be calculated based on their final salary. So if you wanted something else to apply, you would agree that.
But since you wouldn't know whether or not that would be the case in the future for the employee and the employer in both of their interests, it would be better to fence that, ring-fence that gratuity that they have accrued.
And just to be clear, that obviously only applies to employers that are falling under the labour law. There is a different position now, of course, under the DIFC employment law, where gratuity has been replaced with the obligations to make contributions into a qualifying scheme.
Sorry, we have so many questions. We're trying to get most of them answered, and in the end, we'll see whether we have enough time to take a few more. So we're talking about the immigration restrictions, and you've clarified the scope of those new restrictions. What will their impact be on? Is there any impact on UAE employers other than visas, which
So I mean, I guess the main impact is on recruitment, and as I said, it's on recruitment from outside of the UAE. So it will have an impact on recruitment timeframes if you were looking to recruit from outside of the UAE. As we've said, you'll need to think about whether you can extend the start date or whether you need to withdraw the offer. I suppose we may see more poaching from within the UAE, given you can recruit from within the UAE but not from outside at the moment, and the usual considerations in terms of post-termination restrictions, etc., would therefore apply.
So non-compete clauses.
Exactly, yeah.
It's going to be an interesting time. So travel restrictions. This is also one area where we've had so many questions, and that also relates to health and safety, obviously. So first of all, can employers prohibit employees from going to specific countries on their personal leave? So we've seen earlier that you said the court is more likely to side on the side of the employer if the employee has made travel to high-risk areas and then needs to stay home and is not paid. But can an employer formally prohibit an employee from going to a specific country?
In short, no. As an employer, you don't have a right to tell an employee where they can and can't go on holiday. You can obviously issue guidelines. I think it's very sensible to do that. I think it's also very sensible to warn employees of the implications if they do travel to a high-risk destination and are required to isolate. But we come back to this point of if you travel to this jurisdiction, you come back, you're isolated, we're not going to pay you, you've then got a risk that employees simply won't tell you.
Yeah.
So there's a balance to be struck.
So that goes back to the very first questions around whether someone has COVID-19 and they should tell you, but then if they're afraid that they will not be paid, they might not tell you. So you do want to strike a good balance of being strict and fair, but also leaving enough room so that your employees are transparent. Because at the end of the day, you can't verify where they've gone.
Yeah.
An employee went abroad on a business trip and they are now stuck in quarantine or stuck abroad due to flight cancellations. First of all, that I don't know whether the answer will vary, whether it's a quarantine or stuck outside. Do we have to pay them on a business trip?
Yeah, I mean, I guess the answer to lots of these questions is yes, from a legal perspective, you need to pay them because, as I've said, there's no legal right to unilaterally impose unpaid leave. But I think particularly where you as the employer have requested that an employee travels for business and they have ended up being quarantined as a result of that, it's very hard to see how you could justify either legally or morally making a deduction from their pay.
Yeah, so whether unpaid leave or pay deduction seems a little unreasonable if you have asked them to travel. So many companies have halted non-critical travel and instructed their staff to avoid attend meetings and events. And so far companies, but in some countries governments have done so. But can an employer require that its employees attend events or keep traveling? And what if an employee doesn't feel comfortable doing it?
Yeah. So again, I guess there's kind of the legal answer and there's the practical answer. So from a legal perspective, you as the employer are entitled to make reasonable requests of your employees, and depending on their contractual terms, that may well involve travel for business, for example. I used the word reasonable before, and I guess that's the key thing here. So why are they traveling? Is it really necessary? Or can it be done remotely, for example? If it is really necessary, what measures can you as the employer put in place to try and protect them? So it's something that needs to be considered on a case-by-case basis, I suppose.
So I guess, I mean, there is a few, meetings and events, there is a lot of companies that are still requesting that their employees do so, but I guess there is more or less risk, right? So in an industry like, for example, the pharmaceutical industry, where most of the sales representatives will be working in hospital, would it really be, well, you know, again, it goes back to reasonable. So it was presumably wouldn't be reasonable to asking your teams to continue performing their work in hospitals at this time.
Yeah, I mean, so I think all of these specific questions require thought. But I think to take a step back and look at the bigger picture, as an employer, you have duties to protect the health and safety of your employees. Aside from the legal obligations, you obviously don't want your employee to get COVID-19 because they may then spread it amongst the workforce. You may have to temporarily have everyone working from home. So clearly there are lots of reasons that you want to protect your employees from COVID-19. So in the same respect, business needs to continue as much as possible. So it's really the same thought process and the same risk assessment as we went through in terms of travel. You know, is this really necessary? Are there other ways that these meetings, visits can take place? What measures can you put in place to try and protect them?
Yeah, so that ties in nicely with the next thing that we're tackling, which is health and safety. So obviously we're saying employers have a duty of care and they also have to care for their employees' well-being and need to keep in mind bigger implications of what they're doing. So it's not just about short-term gains, even though that might be impacting you hard right now in terms of business to not be able to go do business development. So there are reputational risks, as well as look at your employer brand and how you're taking care of your employees in general. At the end, I will point you towards resources that the CIPD has developed in the areas of well-being, mental health, flexible working, etc. So if that's of interest to you. What legal obligations, besides what we have already said, which is you have the moral and legal obligation to care for your employees, do I have specific obligations as an employer to protect the health and safety of my employees? Is it a very square area, or is it, again, depends on the case?
Of course, it's not a square area. No element of employment law or health and safety law it is. But actually, health and safety is an area where it's particularly grey, I suppose, because there is no dedicated health and safety law here in the UAE. There are numerous pieces of legislation and regulation that set out an employer's health and safety obligations, some of which are Emirate specific, some of which are in free zone rules and regulations, some of which are sector specific. And so, you know, each of the listeners to this webinar will be subject to slightly different health and safety obligations depending on the nature of their organisation, their regulator, where they're registered, etc. So it won't be possible to kind of get into specifics. But in terms of the kind of bigger picture, yes, as an employer, you're under an obligation to protect your employees' health and safety. What that means in practice will obviously depend on who you are, what your organisation does, your employee demographic, and it comes back really to what's reasonable, common sense. You know, you want to be able to show if there is ever a dispute around whether you breached your obligations to protect an employee's health and safety. Can you justify what you've done or haven't done? You know, have you got policies and procedures? Have you carried out risk assessments? Can you demonstrate that the measures that you took were reasonable?
So it goes back to what you said earlier. It's all about being evidence-based in this system and being able to prove what you have done.
Yes, very much so.
So I assume that a lot of questions around that will pretty much be different versions of the same question. So obviously the World Health Organization has been issuing guidelines around preparing everyone for the right, I guess, things to do, but also around preparing workplaces for work. If an employer doesn't appropriately take care of sanitizing the office after someone is contaminated with COVID-19, for example, can they be held responsible for any additional contamination? So we have someone in the office who is contaminated, the employer knows it, doesn't take extra precautions to clean up the area, other employers get sick, am I responsible?
I guess I'm sure we will see litigation arising out of this area, and as to whether liability arises will very much depend on the circumstances. From an evidential perspective, I think it will be difficult, given the incubation period, for individuals to demonstrate, I contracted it here. So that's obviously one thing to think about in terms of litigation. But I suppose, again, in terms of the bigger picture, you as an employer have an obligation to protect your employees' health and safety. So where you become aware that an employee has COVID-19, of course, you should be taking reasonable precautions to try and protect against that.
So far, obviously, there is nothing, and we've said that at the beginning of this session, there is nothing that is COVID-19 specific in the law. If tomorrow the government was to issue a law or a guideline saying all workplaces must clean up, then that would become a law and you would have to do it, right? It wouldn't be a choice anymore. So long as the government hasn't spelled it out, it is your responsibility. But if the government spelled it out and you read it in a newspaper that authorities have mandated that you do so, then you must do so.
Yeah, I mean, I'm not sure I would rely on what the newspapers say.
It's really hard to find information. It is really hard.
I would rely on what the gazetted laws say, because there are sometimes are miscommunications. But yes, of course, if the government issues laws and regulations around anything to do with COVID-19, then you as an employer should absolutely be complying with them.
So, I mean, all of the other questions are around, it's all that. So if someone contracts if someone contracts a virus at work, can they be liable while traveling to work? So again, I covered this pretty extensively. Depends on whether they can prove it and whether you can prove that you have done the right things as an employer, but you do have a duty of care. And also it's important that you think as an employer, as you're putting together your regulations, laws, and procedures, that you think of what can you do to enable, one, your employees to perform well and be motivated, and two, enable them to be transparent with you so that they're not scared of reporting the case, right? I think that's really, really important. I don't know whether we have any questions specifically around health and safety. Again, around pay, the big topic. We'll get back into pay, I guess. So far, we did want to touch upon two more areas that are less talked about, but arising. The first one is around privacy and data protection. So should an employee be suspected or confirmed to have contracted COVID-19, and the employer knows about it, do employers have a responsibility to report the information? And if so, to whom?
Yeah, okay. So I suppose, so there is no specific legislation saying that employers need to report it. There are regulations for the clinics themselves. And so if COVID-19 is confirmed by a clinic, they themselves will need to report. I also think it's sensible and indeed guidelines suggest that employers should contact the Dubai Health Authority and obviously act on their instructions in terms of what you do to protect the rest of your workforce and what you do in terms of your premises. In terms of other reporting, so yes, that deals with the authority side of things.
So as an employer, do I share the information with the entire company or just with the close team? Yeah. Do I have obligations around that?
So I suppose the first point is you need to understand what data protection legislation or rules apply to you, and that will depend on whether you're in the DIFC or not, and whether you fall under the scope of GDPR. But as a general comment, there is a balance to be struck around protecting the privacy of the individual, but also protecting the remainder of the workforce. So from a practical perspective, I suppose the rest of the workforce probably does need to know, or often will need to know, that someone has it and the measures that are being put in place as a result. But they don't necessarily need to know who.
Okay, but also, so as an employer can make a lot of assumptions. So they can assume that you're working only with your close team. I could have a colleague I work with very closely who has nothing to do with my department. And so if I don't know who it is, I wouldn't know whether I've been exposed or not. And potentially I'd go to quarantine and I contaminated other people. So it's really about that balance, I guess.
Yeah, and I mean there is no right answer. Yeah. You know, if that situation arises, there is a risk assessment needs to be undertaken in the knowledge of the data protection law that applies to you.
So if I am the employee who got contracted the coronavirus, and my employer broadcasts it internally or externally, depending on my profile, can I assume that it damages my reputation and sue my employer for that?
Yeah, so potentially. So again, it depends on which legislation applies. But there, in the penal code, there are very broad-reaching offences around defamation, and so certainly that's potentially something that could be relevant. There are also specific rules and penalties under data protection legislation.
And without going into defamation, because again, that's like a whole bucket of its own, would that depend on my rank? So let's assume if I'm a high-power CEO, would damage my reputation potentially more so than if I'm a regular employee with less visibility and exposure? Or would that defamation, would defamation be the same thing for both profiles?
Yeah, I mean, it's a provision in the penal code. It's something that it applies to everyone, and also, you know, it's not just the defamation. Obviously, it's the privacy, the data protection considerations as well. So employers do need to be extremely cautious in terms of how they report instances of confirmed COVID-19 cases, because they could potentially fall foul of various different pieces of legislation.
That's an interesting one again, because I guess as government you would want to encourage, and as health organizations, you would want to encourage employers to report to you. So be flexible enough with them so that they can feel comfortable doing so. You also need to make sure that they do what they do, and that could sometimes deter them from wanting to report to you.
But I think there's two different issues there. There's reporting to the authorities, which absolutely you need to do, and you need to comply with any guidelines that they give you. And then there's reporting more broadly within your organisation, and that's where you need to be particularly mindful about what information it is you disclose.
Yeah. Can employers collect just any information on their employees, and should they? So let's say we're still having employees who are traveling. Should we ask them where they have been the past 14 days that we can prevent them from entering in contact with people who have not traveled because we care for our employees? Or is this not okay to ask such data?
Yeah, so I mean, I think those sorts of questions are very sensible, and those sorts of questions are being asked of visitors onto premises, of applicants who are being met for interviews, and it's a sensible precaution to take. But you obviously need to do so with regard to the applicable data protection legislation, much of which will require that you provide employees or visitors or whoever we're referring to with information in terms of, for example, what the data will be used for, how it will be used, etc.
Yes, because then you could start assuming that you could just ask about any question at any time to your visitors. So it has to be controlled. So so I guess that covers the most commonly asked questions. Yeah, no, I guess we're good with the privacy and data protection, unless anyone has specific data protection questions, please. Not paid. Is there a UAE law in place for COVID-19? If yes, yeah, where could I find it? Well, we would love for that to happen, but no, there is no specific laws around COVID-19. That's what we're.
Yeah, so there's no specific legislation, particularly from an employment perspective. You're referring to. Obviously, the government is issuing, and various authorities indeed are issuing guidelines on a regular basis. So that's really where you're going to find your guidance, your rules, as opposed to a law as such.
Yeah. Unfortunately, it's not that straightforward. And there is a lot that comes into play here as well. Obviously, we're talking about the legal implications, but also the moral implications, the ethics, the right thing to do, the duty of care, and of course, the imperatives of business. So it's quite difficult. So the last theme that we'll talk about today before taking your questions is around discrimination, harassment, and social media. So since the beginning of the outbreak, there has unfortunately been a surge in discriminatory comments about people from certain nationalities or certain parts of the world, even though it's increasingly difficult to do so because it's not everywhere. So maybe that's a good thing. But what does the UAE law say about discrimination? What if I am from a certain background, and mainly, I guess, we're talking about Asia and the continent, and I'm hearing discriminatory comments or jokes about COVID-19?
So it's certainly an issue that employers and indeed employees need to be alive to. Under the DIFC employment law, there are comprehensive anti-discrimination provisions and compensation that applies where they are breached. Onshore, under the labour law, there have very recently been limited anti-discrimination type provisions introduced, but there is also an anti-discrimination law. Historically, the anti-discrimination law was focused around religious discrimination, but there has recently been an amendment, so it now includes gender. So both onshore and in the DIFC, there is an anti-discrimination regime of sorts, and there can be penalties either on an individual basis or for companies where they are breached. From an employer's perspective, I would recommend this anyway, but if you don't already have one, I would strongly recommend that you put in place anti-discrimination policies. Employers can be vicariously liable for acts of their employees. So if your employee makes a discriminatory comment to a colleague, for example, there are circumstances in which you as the employer could be vicariously liable. And so it is sensible that you have policies and procedures that clearly explain what is acceptable and not acceptable. Even if you have a policy in place, it would be worth issuing training to employees now on what that means in the context of COVID-19 and what you can and can't say and do.
Do employees need to be mindful of posting, and I guess that's both a privacy and a discrimination question, do employees need to be mindful of posting about COVID-19 on social media?
Yeah, I mean, I guess it's something that lots of listeners will be very familiar with anyway, if they're based here and they've been based here for a while. You know, we all need to be careful about what we post on social media. There are very strict laws in terms of what you can and can't post, and you need to be particularly careful where what you're posting could be seen to be potentially derogatory or damaging to the UAE. So absolutely, employees do need to be careful about what they're posting. As an employer, you need to be careful about what you're communicating. You need to stick to facts and government published information to try and avoid running the risk of kind of fake news.
And I guess we're all seeing a lot of this. So we at the CIPD are trying to get resources to support our members. We stay within the realm of HR, obviously, but many companies right now are publishing reports and facts and potentially what could be perceived as medical advice. Can they be held liable for publishing such information on social media in the case that someone would follow it and get consequences for it, or in the case that it was wrong and potentially endanger people?
So I guess it's really difficult to answer those kind of specific questions in terms
when you
of
get
claims,
is there a risk when you get into talking about, I guess, health and safety issue and medical advice in general? Could you, is it risky saying such things? Are you better off just copy pasting what the WHO is saying?
I mean, to kind of bring it back to an employment context, certainly from an employer's perspective, in terms of what you're communicating to your employees, you don't want to step into the shoes of trying to give medical advice. What is more sensible is to convey the advice from the World Health Authority or from the UAE authorities, for example.
Okay. So I guess that concludes most of the themes that we wanted to discuss. Obviously, discrimination is something that is not to undermine. It can hugely impact the mental health of your teams, and not just those that are being discriminated against. We do have a number of resources, again, around this, and also we will link that. But the World Health Organization has issued a really great guidelines around how to talk about COVID-19. Things like avoid saying victim, because that implies that there is someone who is guilty of spreading, etc. So just in general, be careful about what you are saying, and look, I guess the main message I want to drive home is that you need to look after the well-being and the physical and mental well-being of your people, as well as of their performance, of course. I've seen a few questions around how long are the bans for, how long are these extraordinary measures for at the moment. I guess so far all countries have said it's open-ended.
Yeah, exactly. So some of, in terms of the immigration restrictions, it's just a temporary suspension. We don't know when they will end at present. Some of the other restrictions, so in the education sector, for example, obviously there have been dates published in terms of distance learning and closures, etc.
But it doesn't, we don't want to spread fake news. Nothing has been confirmed so far in terms of extending those dates, but it could be that they are extended. So far we don't have a deadline as to when this is going to go away, unfortunately. Yeah, because I've seen that question, and to know we don't have that. So would it be the legal way to reduce my, so a lot of questions around, sorry, I'm trying to read your questions, everyone, a lot of questions around pay, of course. So from Hajar Saleh, back to the previous part, what would be the legal way to reduce my cost as an employer during this period? Because we've talked about consent and employees having to give their consent. So if they don't agree, what would be the so if they have to agree. If they don't agree and may be sued as an employer for wrongful dismissal, potentially arbitrary dismissal. So what would be the legal way to try and alleviate the pain that this is having on the business?
Yeah, I mean, you've answered the question really. So the legal way of trying to reduce your costs, your staffing costs, is to do it with employee agreements. And we obviously talked about that earlier in the session in terms of how you go about doing that, going through some sort of consultation process, making sure employees know why you're suggesting these measures, what you're going to do to try and alleviate some of the impacts in terms of gratuity, etc. So that is the legal way of doing it. You do it with employee consent. If you don't get their consent, you then get into the more risky measures, which is doing it unilaterally.
And that could potentially bring you to at least a lawsuit, and potentially you could be found to have been arbitrary in the dismissal. Is it legal if an employee has accrued vacation days to still take unpaid leave? Yeah, that's a good question. I'll get confused. If an employee still had, we talked about paid leave and unpaid leave earlier, still have paid leave balance, can I still ask them to take unpaid leave?
So you asked the question in two different ways. The first time you said, can I make them? And the second time, can I ask them? Yes, you can ask them. You can ask employees to take unpaid leave. And if they agree and document that in writing, that's fine. Can you tell them to take unpaid leave? It actually doesn't matter whether they have accrued leave or not. The law doesn't provide any legal mechanism for you to compel someone to take unpaid leave.
So for those who came late during the session, so I think there's 50% of you who came later, Samantha was talking earlier about trying to find, of course, agreements and compromises with employees. And one of the solutions that she was suggesting is that employers may make it possible for their employees to borrow leave days from the next years, so that it's a solution that may work for them both. That might make it harder for the following years for them, especially as expats. Is it legal to conduct thermal test for staff in the accommodation or entrance of the hotels? That's privacy as well. Can you do that?
Yeah, exactly. So it's actually it's a tricky question, and it's one that would kind of require a bit more questions of you in terms of where are you based and what law do you fall under. But from a general perspective, you're right to ask the question and to be cautious, because there are issues around privacy and what you do with that data, getting consent, etc. So it's something that needs to be considered before you implement it, certainly.
Great. I think we're just wrapping up now. There is some potential really challenging outcomes of this unpaid leave situation. So I've seen some questions around, well, if you do ask people to take unpaid leave or agree with them that you will take unpaid leave, does it mean that also their accommodation will be unpaid? So I'm guessing that's certain industries like airlines and hospitality where accommodation is provided. I'm guessing it goes back to what we said earlier, they have to consent. You probably legally it's not pretty okay to just throw people out and remove their accommodation and remove everything.
Yeah, so it's you know the whole unpaid leave regime isn't provided for under the law. So it's if you are agreeing it with employees, then you need to think about what that means in terms of all of their ancillary benefits. Yes, from a legal perspective, because they're still your employee, you still need to provide them with health insurance. All of the other contractual benefits over and above, like accommodation, it's something that you would need to contractually agree. But yeah, from a practical perspective, an employee's not going to agree to an arrangement that would require them to exit their accommodation, of course.
Yeah, absolutely. So, I mean, lastly, we spoke about flexible working a little bit earlier. Does anybody have questions specifically relating to remote working? We have questions around dependencies, visas. So this situation might mean that somebody will lose their job and has to go on their spouse visa. Where do we stand if the spouses work in jobs that involve, where do we stand if spouses work in jobs that involve travel, such as husband is a pilot, and they are mixing with kids? Well, I guess that's not very much of an employment law question. Not really sure
what the question is.
Well, I guess potentially it's a risk because you're not in quarantine, that's for sure. But I'm not sure what that question would be. Kerry Wyckoff. Where can we find the official list of countries considered as hotspots? So the situation is evolving dramatically quick and daily. What are your sources for information?
Yeah, I mean, it's so I guess lots of the updates have come through the media in the first instance, because there isn't legislation underpinning it for which you would go to the Gazette. Lots of this is coming through the media, and you then see kind of official updates come out afterwards. But clearly the source that you should be relying on are official authority, regulator, government updates.
Okay, so the last question's on working from home while we were getting that information. So can an employee decide to work remotely without agreeing first with their employer? So this is one of the questions that is covered in our FAQs that we regularly update. I'll let you answer.
Yeah, so an employee's employment contract will typically say your place of work is the company's offices, wherever, and so they are contractually bound to come to your office. So to answer the question, no, they don't have the right to unilaterally decide to work from home. It needs to be with the agreement of the employer.
It needs to be agreed, even if I don't feel safe working in the office.
Yeah, I mean, that doesn't give you a right to breach your contract, but from a practical perspective, employers should obviously be listening to those concerns and trying to facilitate home working where possible, particularly for more vulnerable employees, so those who are pregnant, those who have autoimmune diseases, etc.
Goes back to leadership, communication, well-being. When it comes to flexible working, we've put together a toolkit which includes a ton of things, including a checklist, things to keep your teams engaged, and everything is free, not just for CIPD members, but for everybody. So if you want to know more about that topic, we'll link those resources later. In the case of a lockdown by the government, will that be considered as unpaid leave if the organization does not have remote working option? Yeah, so there is always a question of some jobs can be performed remotely, others can't. And I guess that brings a question of fairness, which from our perspective, we really encourage employers to be flexible with the jobs that allow to be performed remotely, and shift the narrative or make sure that they explain the reasons behind this to the employees who cannot perform their duties from home. So for instance, if most people working from home, but you still have a receptionist working at the office, or people who can't work elsewhere, it's about communicating as well and saying, well, it's not that they all have rights that you don't, is that right now our priority is your health and safety, and it is also in your interest that there are as few people as possible in the office at once. So it's really shifting the script instead of making it like it's unfair of the person, really making sure the person understands that it's also in their interest. But obviously, fairness is a question. So some companies consult. So I guess like a lot of the questions we have then discussed already. So unless we have some last considerations that we want to say, anything that, what's the number one most asked question that you get?
So reflective of lots of the questions that I've seen coming through, I think what the question that we've seen most is around unpaid leave and the circumstances in which you can enforce it or not, either around quarantine situations or where, because of lockdowns or closures of schools, for example, you can impose unpaid leave for a period of time to try and alleviate some financial burdens.
So I guess that's the final question. In the case of government lockdown, which would force everybody to work from home, do private companies still have to pay you and try and work from home, or do they have to consider that this is unpaid public holiday or public holiday?
Yeah, I mean, I suppose it would somewhat depend on the terms that were issued by the government. So there are examples in other jurisdictions where the government has specifically said this is public holiday. So it would depend on the terms of it. And unless with that lockdown they changed the law, everything that we said would still apply. So if, for example, the government said everyone now needs to work from home, no one's permitted to come into the workplace, that doesn't alter the labour law, that doesn't alter an employee's contractual terms, which are that they are entitled to receive this salary, you know, on a monthly basis or whatever the case may be. So you then come back to, from a practical perspective, first of all, look at, can you facilitate home working in some ways? And that requires some creativity for some organisations. And then if not, can you agree periods of unpaid leave? Can you agree sabbaticals, etc., as an alternative to having to make headcount reductions?
Yeah. Well, thank you so much, everyone, for attending. This is it for today. We have recorded the session, although it is a little bit long. It will be made available if you wish to refer to it. We have worked in partnership with Clyde Co to develop FAQs. So we have published a document around covering most of these questions actually in writing, and that is being updated regularly. And Sam and her team have just developed a similar document for Saudi as well. All right, so we may be hosting future webinars around Saudi labor law particular, so please stay posted. Here are some resources if you are interested in knowing more about working practices guidance. And finally, Clyde Co is CIPD's exclusive partner for everything that is employment law. And so Samantha is usually delivering actually our UAE labor law short courses. That is a 2-day course. What do we cover usually in that course?
I mean, everything. Basically, the whole employment cycle. So chronologically, really, from recruitment to immigration to the standard terms and conditions, contractual issues, terminations, through to post-termination issues like restricted covenants and confidentiality.
Yeah, that's a really, really information-packed course, which is normally 2-day long, face-to-face. We are looking into hosting this course online over a longer period. And of course, that would also include considerations around what is currently happening. Thank you very much all for joining us. We'll see you soon.
Thank you.
Thank you.